Imagine this. A parent dies, and something about the will or trust just doesn't make sense. Maybe a new document suddenly appeared. Maybe a caregiver inherited everything and you've been completely cut out. And you're thinking, wait, this isn't right. I need to challenge this. But here's what most people don't realize. Not everyone is allowed to go to probate court over this. Even if something is wrong, that doesn't automatically mean you're allowed to challenge it. The judge is going to ask one question first. Do you have the legal right to bring this case? My name is Angelique. I'm an educator, not a lawyer. I'm someone who had to represent myself in probate court when I couldn't afford a lawyer. This video is for educational purposes only and not legal advice. So let's start with that question. Do you have the legal right to bring this case? In legal terms, that's called standing. You can think of it this way. Do you stand to gain or lose anything depending on the outcome of the case? Because probate courts don't allow just anyone to challenge a will or trust. You must have a recognized legal interest in the outcome. In California, the law uses the term interested person. That's how the court recognizes as who has standing. So who qualifies? In probate cases, this usually includes heirs, like a spouse, child, or close family members, beneficiaries named in a will or trust, someone who was included in an earlier version of the estate plan, or sometimes a trustee or executor, depending on the issue. But here's something important. That definition isn't fixed. Whether someone qualifies as an interested person depends on the specific issue the court is being asked to decide. Here's a simple way to think about standing. If the court fixes the problem, for example, by invalidating a will or trust, and the estate is treated as if there were no valid document, does money move into your pocket? If the answer is no, the court may decide you are not the right person to bring the case. So why does standing matter? This part is critical. If you don't have standing, the court may dismiss your case before it even begins. That means no testimony, no evidence, no explanation. The case can end before the judge ever looks at what actually happened. And this is where people get tripped up. Even if something suspicious happened, you still have to show that the outcome would actually benefit you. For example, if an earlier will gave you something, but a later one removed you, you may have standing. But if every version leaves you nothing, then even if you win, your situation doesn't change, and the court may decide you don't have standing. Another scenario where a person often trips up. Sometimes people care deeply about what happened. A neighbor, a close friend, someone who witnessed concerning behavior. But probate court doesn't operate on who cared. It operates on legal interest. If you are not an heir, beneficiary, or otherwise legally affected, you usually do not have standing. Lastly, this one surprises a lot of people. If the person who created the trust is still alive and mentally competent, beneficiaries usually don't have standing at all. They typically cannot demand information, challenge the trust, or take legal action. Because legally, the trust still belongs to the person who created it. Your right usually begins after the person passes away. So now, let's zoom out for a second. Standing is just one part of the bigger picture. Before probate court will hear your case, you need three things. First, you have to be within the right time, meaning within the statute of limitations. Second, you have to be the right person, meaning you have standing. And third, you need a legally recognized reason. That's what I'll walk you through in the next video. So, if something feels wrong in a will or trust, don't just ask, is this unfair? Ask, am I the right person to bring this case? Because if you don't have standing, the courts may never reach the facts. If you want help thinking through your situation, you can take the free quiz link below called Do You Have a Probate Case? It walks you through these same three requirements and helps you start evaluating your situation. You'll also receive a free checklist to help you begin gathering the information you may need.